Hello, Richard Morris here from Morris Succession Lawyers, coming to you from the beautiful Rainbow Beach in Bonny Hills. Beautiful day today. It's been pretty wet and wild for the last little while, so it's good to see the sunshine out. I just thought I'd have a quick word today about disclosure in family provision matters. It's something that we often get a little bit of pushback from clients who are defendants in family provision claims. So it's relatively commonly known, or it's common sense really, that if someone is bringing a claim against a will and seeking either further provision or provision from an estate, then they need to set out what their financial need is, and in the process of doing that, they set out their current income, expenses. You normally see monthly ingoing and outgoing of funds in a table that's in the standard form affidavit. Normally you would also want to see bank statements attached, superannuation statements. It's not unusual for those to be provided, or at least asked to be produced under a notice to produce. Centrelink statements, all those sorts of documents, vehicle registrations. Every detail to do with a third person's finances should be disclosed and must be disclosed in the initial affidavit that goes with the summons, as well as details of their spouse or anyone else that they're relying upon or who is liable to support them. So all of that should be provided. Pretty straightforward. Sometimes plaintiffs aren't particularly keen to provide that sort of information, but it's simply a must, and a court is never going to consider a claim unless that disclosure is provided. And personally, if I'm acting for a defendant and a plaintiff's failed to provide that information, then it's going to be very difficult to justify making any serious offers, which can be an impediment to pre-litigation settlement, because sometimes people will try to keep their cards close to their chest, which is just counterproductive when it comes to settling family provision claims. On the other side of it, you've got the defendants. Sometimes they may wish to raise their circumstances, or beneficiaries of an estate may wish to raise their circumstances, and effectively they're saying to the court, look, don't take money away from me to give to the plaintiff, because I have my own financial needs and I need the interest that I'm meant to receive from the will, and I can't afford really for that to be taken away from me. That's something that beneficiaries may not wish to disclose. They're not the ones who have brought the proceedings before the court. It wasn't their choice. They may not wish to set out all of that information, but if they want the court to take their financial circumstances into account, then they absolutely must provide all that information, and it's information along the same lines as what a plaintiff would provide. So that's the sort of disclosure requirements in family provision. If the disclosure requirements aren't met, then the court may make adverse findings, and I may give some examples of that in the written post that accompanies this video. So that's it for today. Hope you're having a cracker day and your February's treating you well. And as always, if you need any assistance with succession law, wills, estates, estate litigation, feel free to contact myself or the team at Morris Succession Lawyers.